So hello everyone and welcome to another exciting edition of the ESQ Practical Bears Academy Free webinar series. My name is Chidima Abutse and I'm the Research and Development Associate at the ESQ Training Limited. At ESQ Training Limited, our mission is to expand the frontiers of continuous professional learning with courses and trainings across various areas of practice. We have tagged this webinar series Launch Our Webinar Series as they are slated to hold at 1 p.m. during lunch breaks. They will hold 3 times every week, Mondays, Wednesdays, and Fridays. However, in order to accommodate our Muslim participants, we hold our Friday webinars at 11 a.m. And after every session, we try to provide the resources to those who are interested in them. So, before I go into the topic of today, you can now watch our webinars, both the past and the present, on our YouTube at my ESQ Legal. And please, when you're done watching, kindly subscribe and like. Thank you. So, topic today is on data security for law firms, and some of the things that our panelists discussing today will be the meaning of data security, the law of data security, essential data security guides for law firms, and ways of securing data, and many more that our panelists will be touching on today. So while the webinar is ongoing, if you have any questions, please type them in the Q&A or you raise your hand and anytime will be answered. So thank you once again, our panelists, for joining us today. We are honored that you join us today. Firstly, we have Mr. Olusegun Adeyemi. He's the managing partner at Hashtop Solicitors. He will be our first panelist today. Secondly, we have Mrs. Motrayo Ogunseyitan. She's an associate at Alupo, and sorry. Thank you so much for joining us today, ma'am. We have lastly, we have Mr. Levi Chiefuna. He is an associate at Keishiku and Co. Thank you, Mr. Levi, for joining us today. We are so happy that everyone is here today. So please, like I mentioned, while the webinar is ongoing, if you have any questions, please send them Q&A. So I'll leave Mr. Shegun to start kick off the topic for today. Thank you.
Okay, thank you very much, Jim. I am now going to share my screen. Hopefully. Bear with me 1 second. I'm not sure why my presentation is not coming up amongst. Okay, there we go. So thank you very much for giving me the opportunity to present at your webinar. The topic that has been posed to me is data security for law firms, and I saw the narrative and we're supposed to come and offer suggestions on how, am I being clearly heard? Can you hear me?
Yes, sir.
Okay, so that is the idea. But what I have done is to add a little slant to it and speak to this issue from a very high level perspective, rather than the granular specific policies that we will need to develop. But everything, and I trust that my other colleagues will pick up anywhere that I may have left off, and so that we can have a rounded discussion on this. So I'm starting from the position of law firms. I mean, what is a law firm established to do? What are the key functions of a law firm? Primarily is to provide legal advisory on the rights and liabilities of individuals, of corporates in the event of mergers, acquisitions, in the event of general corporate transaction. Lawyers also provide legal representation in civil and criminal litigations, and also for business transactions. We also provide corporate secretarial services in addition to our general legal services. In the course of all of this, we do come into possession of a lot of information that has been passed on to us by our clients, which we as lawyers have an obligation, or we have obligations to make sure that we keep confidential. These obligations also are imposed on us by guidelines, by statutes, and by regulations. As lawyers, the rules of professional conduct clearly admonishes us to ensure that in the course of our professional employment, that all communication between our clients and ourselves remain privileged. The Evidence Act also makes reference that no lawyer should be obligated to disclose any communications with their client in the context that it is privileged. So it is always known that the core obligation of a lawyer is the confidentiality, and they must take every step to protect that confidentiality. Recently, the Nigerian Data Protection Regulation, also by virtue of Article 2.6, which refers to data controllers that keep, process, store personal data of Nigerians, which will include law firms, to take steps to ensure that they provide adequate security for the email, for the data that they keep. So it has been a core obligation of the legal practice that the confidentiality of information is sacrosanct to the discharge of our services to our clients. But what we find is that we've moved away a lot from the traditional, where we keep it in brief, where that confidential information is usually stored in lockable drawers and kept in files, and we only ever exchanged emails. The introduction of the internet and the easier ways of communication has meant that we now depend a lot on information and communications technology in order to be able to communicate with our clients, in order to be able to share this confidential information. So you might have you have a scenario where an average lawyer has an iPad, they have two phones, they are connected to the internet, they are connected to the office server via their phones, their iPads, and their computers at work, not to talk about their personal laptop that they keep at home, in which they also use sometimes to effect client work on their personal laptops. Of course, as a result of this, the level of risk to that confidential information has been heightened. And look at what we're going through today. There's many cases of cyber attacks. But for law firms, they not only face the risk of these cyber attacks, which can lead to data breach, they also face the risk of liability in terms of where there has been unauthorized disclosure of confidential information, either obtained through illegal act or what. And we will quickly go through. I know I have 15 minutes, so I'm quickly talking through all of this. So this has made it important that the protection of data and the protection of information generally has become a major challenge, not just for law firms, but organizations that use information and communications technology to carry out our businesses today. Now, what types of risks and specifically what types of malicious software are out there that could imperil a business or put us in this risk? So what I have done is just to quickly give you the ways in which law firms can become vulnerable to data breaches. Usually they come through the spyware. Spyware, they're just malicious programs that are designed to connect to your computer or to your device, and they just sit there listening to all types of people. And that spyware can come from any angle. If you look at the way we live our world today, most of the time, the first thing that we do when we wake up is to check our WhatsApp, to check, and we get lots of messages, we get lots of files and images and videos and memes to which we play. We never know what is hidden in some of these applications that we just run on our phones. And we do that, we check our emails using the same application, using the same device to check our emails, official email in which there is client communication. So we stand the risk. You can see me, but I'm sure they will change the power over very shortly.
I think we've lost Mr. Shegun. Can we just give him a moment to join us? Sure.
Breaking transmission. Hope you can still hear me. So we're looking at the ways in which environments can become compromised, leading to a data breach. So I talked about the spyware being a malicious software that is designed to gather data, to enter into your computer and gather data. And this may include some of this confidential communication that between our clients and ourselves. Another major way is the hacked email, the true email spoofing, which we're all vulnerable to. But the most dangerous of all, and what we have seen in the last few years, is this what you call ransomware. It's a malware that is designed exactly to, again, hold organizations to ransom. And if you look at it, the bigger the organizations, this ransomware target very big organizations. They seize all their files, they make them inaccessible, and then they request for some ransom, and that's how come the name ransom malware, to pay some ransom before they can.
I think Mr. Shegun's network is very, very unstable. So I would have suggested we pay. I think he's eating out of his time. And go through with your to have to wait till we are done, then continue. Hello, Ma, are you there?
Yes, I am. Sorry, I didn't know what you said.
confirm from Mr. Shegun if, since it's now, would ask him if we would have to wait for him to get his network stable before he goes on his presentation while you make yours. So let me ask him, Mr. Shegun, sir,
Yes.
your network,
Yeah, my network seems all right, but it seems to be fluctuating. I am not sure whether you can hear me now.
Yes, we can hear you now.
Yes, we
I
can
think
hear you now.
I've got about another 5 minutes, if you can bear with me.
No, you can speak further since the network.
Okay, so yeah, so these are the issues facing law firms in the event of data breach. So we have regulatory obligations. Like I mentioned, we have the data protection regulation now, whereby in the event of a data breach, a law firm may be liable to fine. We have the issues of legal challenges, breach of confidence, that law firms are also liable to. We're not talking about the economic impact of a ransomware attack on the firm and the reputational damage that will come as a result of being exposed, a law firm's organizational structure being exposed, or information about our clients being posted out on the World Wide Web. So if you look at all of this, it makes it imperative that information security management is critical for law practice management. And this is where I will be deviating and looking at this matter from a wider perspective. But in order to be able to drive home the point, I just want to use a case study of an international law firm that was breached. Most, if not all of you, will be aware of a 2016 incident that involved an international law firm called Mossack Fonseca that had their one of their offices in Panama, in which the law firm was hacked and over 11 million documents copied from their servers. Of course, some of this information was published on the web, and of course, the first key thing when this happened, the information coming out of Mossack Fonseca is that financial and clients' privileged information was safe and nothing happened to them. And then the hackers went ahead and published information of some of their clients in which it was even suspected the president of one of the superpowers, transactional information was made available to the public. Of course, Mossack Fonseca made this information known to the public by virtue of regulatory obligation that they were hacked. They tried to play it down, but independent security experts now later on posted and highlighted several vulnerabilities in its email and document management systems that allowed the hacking to happen. And you would note in my earlier slide, when I was talking about the key vulnerability areas, I talked about the hacked emails, I talked about malwares that will enter into the system, steal information, seize information, and these are the risks that we face. And this is how vulnerable law firms and other organizations. So using this Mossack Fonseca, my focus on some of the suggestions I'm making here are at a very high level. Since if you look at the most vulnerable law firms that you would have, are the ones that can pay out huge sums of money. We do not have in Nigeria, as of yet, I'm not aware of any information of a reported data leak to a law firm. It may have happened. We just may not be out there in the public domain. But these are the risks that the big law firms face, and generally organizations that rely on information and communications technology to deliver their work. So what do we do and what can we do about it? And from a corporate governance perspective, any action that we are going to take is going to be focused on 3 key areas in order to secure this data. It's all about protecting the confidentiality of information, such that confidential information, you must have policies, procedures, and processes in place that will make it that will protect it from any unauthorized access, any unauthorized interception or disclosure. You want to have policies, procedures, and processes in place to protect the integrity of that data, that client information that you have, and to ensure that between when you send a message from Mr. A to Mr. B, that message has not been intercepted by a third party and also changed in the course of its delivery. So you have to have proper encryption systems in place to ensure the integrity of the information that you are sending. Of course, you also want to make sure that you are protecting that information, the availability and timely access. So ransomware that attack servers and hold organizations to ransom because they've seized and encrypted all their files is one of those areas where, when you're building an information security management system or procedure, these are the key things that you want to make sure that you cover in order to be able to say that, yes, we are taking steps. It's not just about data encryption, it's a whole gamut of processes and procedures. So how do you go about that? Quickly, is what you call a system called information governance, which is a complete discipline of policies, processes, and procedures. So it's not just limited to, quickly taking one particular step to do this. So you must look at it from an organizational level, rather than, let's go and meet the IT man. They've told us that we should encrypt our servers. They told us, but you need to look at the business of law practice, that the obligations, and you must tie it to our obligations, that law firms now more than ever keep sensitive personal information. Some of the big clients keep information about mergers and acquisitions. Some of the big clients keep about intellectual property designs, which they are applying for IPR for them. So they must recognize that the value of the information that they keep, and they must begin to look at protecting personal data, protecting critical business data at an organizational level. There's really no distinction between when you say information governance or data security. IBM described data security, which is the same practice of protecting digital information from unauthorized access, corruption, theft, which is similar, if not the same, using another language when you're talking about management of information at an enterprise level in terms of your future and regulatory. So you look at our regulatory exposure, you look at our security, information security risk, you look at your environmental risk, your operational risk, because data leak could occur. So there's a difference between protecting data from the compromise of data from outsiders and also from insiders. So you're only as strong as your weakest link. So in developing an information security governance framework, there are certain considerations that need to be put in place. And this is why I said I'm talking about this at a very high level. And I'm hoping that my colleagues will probably drill down and talk about more specific types of encryption, types of password protection and policies. But I'm talking about at the governance level, where in approaching information security or data protection, you're looking at it, the whole gamut. So you must have policies that tell about intention that has been bought in by the senior management, and not just, let the IT person just go and look for something for us. No, it's a governance issue which the management must own. So it's from the bottom up. So you have policies, or top down if you like. If you have policies that make a statement from the partners, from the management, as to how we want to approach information security within the firm, and then from there you start developing standards, rules, regulation, procedures, and operational guidelines. So when we're talking about this, we're talking about information security policies, we're talking about data protection policies, we're talking about things like desktop policies. These are the things that will flow from having is look at the ISO 27001 information that sets out a proper framework for information security management. And anyone who's familiar with that would recognize that it goes beyond just securing your computers. It's a whole 12 domain or 11 or 12 domain process that you would have to follow in order to be able to say that my law firm, my organization has met the standards, international standard that is required to say that we have an information security management process in place that goes beyond just hardware security, that goes beyond just looking at information, because it even affects the choices of when you have this kind of framework and standard in place, it even affects the choices of the service providers. Because if you look at the small to medium firm, medium law firms, they don't have a whole framework of IT structures. They probably use Google Drive to store client files. But what are the things that they need for their own laptops in order to be able to secure them? Then there must also be vigilant. The management spend on providing this security must be visible, and a proper team set up to look at the issues, the constant risks. Sometimes lawyers go out of station and they carry laptops with them. What are the guidelines in connectivity where you go? Do you issue separate telephones that ensure with appropriate policies that you must not use office phones to do personal work? Go to Google, go to Facebook, go to Instagram. So there must be that level of awareness also that comes with having all those tools in place. And the process must also be in place to help you to measure the effectiveness of any security program that you will have introduced. I mean, if you're saying that we're looking at protecting data at an organizational level, and again, I repeat, I'm keeping this at that high organizational level. And then once you have all this in place, one, you can have that comfort that you have at least set up a proper framework that manages security in your, and then you begin to see the benefits of that, because you start to develop that culture of awareness within your firm, and your staff, both lawyers, the partners, and all those that interact with you begin to see the processes that you have put in place. It becomes visible. It becomes the value, because more than ever, clients are now seeking to make sure that the information that they provide to us is secure. They want to know that their business trade secret is available and it is not under threat. And it is through these processes that you have in place that you'll be able to demonstrate that we have effective information security management process in place. And I want to thank you for that, and to apologize for the intermittent stop in the flow of my presentation today.
Okay, thank you very much, sir. Thank you. An apology accepted. Yes, Ms. Motorayo. Okay, I think you can pick up from there.
Hello, everyone. Good morning. It's my pleasure to be here today. I'm just going to take a second to share my slides with you. Okay, so I'm just going to, I hope you can see my slides.
Yes.
All right. Hello, everyone. Once again, it's my pleasure to be here today. Very quickly, I'd like to note that I'm aware some of us might be lawyers, some of us might be IT personnel in our various law firms or various companies. Even if you don't work in a law firm, it's just important that you are aware of whatever we're speaking about today. You can, adapt it in your company, even in the close future. It's just important that you know about data security, because this is a very topical issue. And it's nice to hear Mr. Segun Adeyemi speak. He's covered a lot of ground at a very high level. Thank you so much, Mr. Adeyemi. learned a lot from your presentation. So I'd just like to make it, like he said, at a very simplified level. The first thing I want to talk about is what data security is. These are the learning outcomes that Chidima had earlier spoken about. So I'm just going to be talking about the topic in three highlights. First, Nigeria's legislative framework for privacy and data security. Secondly, the concept of workplace data security. And lastly, the resultant effect of a possible breach. So just to start with, I'd like to differentiate the idea of data security from data privacy. I know that when a lot of people hear data security, they're like, oh yes, data privacy and protection. And then they may wonder, wait a bit, what's the difference between data privacy and protection and data security? I'd like to say that they are very related, but they're not the same. Data privacy refers to the understanding that people's data should be private, should be kept from unnecessary intervention or access, that people have a right to privacy of their data. Data protection is basically the means by which privacy of data is ensured. Data security is also recognizing people's data privacy and making sure that mechanisms are in place, mechanisms and processes are in place to ensure data privacy and protection. So basically, we can say that data security is the means to ensure that we achieve data protection or data privacy. I just wanted to flag that very quickly. So now, moving on to law firms, how do law firms come into play? Why are we talking about data security and law firms? You know, what is it that law firms process or possess that makes them very, exposed to data breach? Firstly, I'd like to say that when we're talking about data security for law firms, we're not only talking about as regards personal data. We know that law firms process a lot of personal data, but that is not the only type of data they process. You know, they process company data as well. You know, personal data is just data of individuals, but you also have company information that you're processing, you have financial information that you're processing, you have confidential information. Sometimes you even have health records. For example, if you're working on a transaction, say a litigation transaction, and you have some evidence of certain staff that had a medical issue, let's say it's a termination of employment scenario, and you have certain staff that had medical issues, so you need a copy of the medical certificate as evidence. That copy of certificate is personal data because it's a patient's medical record. But sometimes you just have company information. You might have company financial summaries. You might have a lot of type of company data that you're protecting. So when we're talking about data security for law firms, we're not just talking about as it relates to data of individuals. We're talking about as it relates to data of companies, of your clients, and even your own data, the law firm's data. So moving quickly, I'm just going to look at the first thing, Nigeria's legislative framework for privacy and data security. I'm aware I have about 15 to 20 minutes. So I'm just going to try and move ahead as fast as possible so that if you have any questions at the end, you can ask and we'll provide greater clarification. So Nigeria's legislative framework for data security. These are some of the laws that provide for data security. We don't really have one legislation that has a lot of provisions for data security, although we have the Cybercrimes Act that talks about computer systems, but we also have bits and pieces of provisions in different legislations that relate to data security. For example, the Constitution, which guarantees the privacy of citizens, their telephone correspondences and homes and correspondence in their homes. That's the Constitution. Then we have the NDPR, which is the Nigeria Data Protection Regulation, which talks about the security of systems and mechanisms through which personal data may be processed, which basically imposes an obligation on data controllers to ensure that they secure whatever means through which personal data is being collected and processed. Then we have the NDPR implementation framework, which was released last year, which basically provides further sheds further light on the provisions of the NDPR. We have the Cybercrimes Act, which, like I said, guarantees, ensures that computer systems and communication systems are being protected at all times from hackers and cyber threats. And then we have the RPC rules, which talks about confidentiality rule in relation to your clients. I'm sure lawyers here are familiar with that. So now moving to the concept of workplace data security. Like I said, it's important to note that workplace data security does not just relate to personal data. It relates to your client's data, financial records, information. In fact, like Mr. Segun Adeyemi said, there are so many categories of data that can be processed by law firms. So firstly, what type of data do law firms process? That's the first question I'd like to answer. Law firms process personal data, information on their clients, litigation documents, information on other law firms as well. You know, sometimes you work with other law firms or even companies at large, and you have information or confidential information relating to them. So you can see that law firms process a lot of information. Then what part of your firm's what part of your firm is responsible for ensuring data security? That responsibility, in my opinion, primarily sits with the IT department. However, it is very important to note that this does not mean only the IT department has the responsibility to ensure data security. Data security should be something that is done firm-wide. It should not just be acts, it should be a culture. So your law firm should have a culture of data security. From the front desk, the reception, if you have one, once someone comes into your office, the receptionist, the HR personnel, the IT support, and every staff of your establishment should have a good culture of data security in the way that they collect information, in the way that they process information. Even when you go to print, when you are at the printer and you're printing certain information, you make sure that you only print what you need, and whatever you print is kept, safe and secure. You don't just drop some documents on your desk. You have a clean desk policy to ensure that nobody walking on the corridors can easily access information. So you have to understand that it's a culture, it's a workplace culture. It's not just acts that you carry on to be in check. So in as much as the responsibility primarily rests with the firm's IT department to make sure that computer systems are safe, to make sure that they have the correct infrastructure for storage of data and all that, you have to ensure that it's a firm-wide decision. But then you also have to ensure that your firm's IT department is made up of competent people who are knowledgeable in IT and infrastructure. IT is definitely one of the growing, sectors right now. So there are a lot of people in the field, there are a lot of people growing in the field. It's important to make sure that you have qualified hands to run your firm's IT department. Then thirdly, methods of securing your firm and clients' data. For example, use of servers, on-site, off-site, cloud. Different people have different methods of storing data. And I just want to draw attention to the fact that when we're talking about data security, we're not just talking about data security on your computer or on your laptops. We're talking about physical data as well. So even if it's data collected physically, you must ensure that this is kept securely. Different firms have different ways of storing data. Some people store physical data. So they have documents, they have a lot of documents that they store in their offices. Some people don't, they have a no paper policy. So they don't like physical documents, which is actually highly recommended. So all that they have is software and, cloud-based documents. They store their documents on the cloud. So what you see here is that all that they do is automated. So they have a system that collects information and stores it off-site. That is what is applicable. But either ways, whether or not you run a paper-based firm or a firm that does not allow physical copies of documents, the important thing is that you secure all forms through which data is collected and disseminated. Also, physical files must be kept securely. Like I said, we advise a clean desk policy. You have to tell your staff that they have to make sure there are no files or documents on their table, and that whenever they are done with a file, they return it back to where it is supposed to be. You have to ensure that there are padlocks so that people don't just come in and steal, a file or a document belonging to a client. You have to ensure that when you're filing your processes, that you don't make extra unnecessary copies. So if you need to file, if you're in litigation, for example, and you need to file 3 copies, you need to make sure you don't make unnecessary copies as well, just to keep it, because you're not going to use it. You make the amount of copies you need, you file the copies you need, and that's on that. Then next, who should have access to clients' data? Should employees have access to USB codes on their PCs, on their computers, transfer documents to their personal mails, use office laptops or phones to access some website? This is very important. A lot of companies say, oh, you are not allowed to use your personal laptop, your work laptop, for personal purposes. This is a way by which they try to avoid employees having access to clients' data. For some is the office phones. You're not allowed to use your work phone for personal purposes, different strokes for different folks. But the important thing is that your employees must always know that they should not access clients' data unnecessarily, and that they should not be able to just transfer documents to their personal mails at any point, because there might be a breach of the personal data of the client or of the company data, and that is going to be, borne by the firm. Then concept of workplace data security. Also, these are just some, I'm sure you can see the slides. These are just some of the manners by which you can ensure data security. One is drafting a privacy policy. A privacy policy, typically, a lot of people think is for the outside community, people that are accessing your website, but it's not just for the outside community or your clients, it's also internal. So your privacy policy would also apply to your employees and your clients and whoever you're transacting with. So a privacy policy is very important, so that you let your clients and your employees know what type of data you're collecting, why you're collecting such data, what you'll be using such data for, and their rights as regards the data, which includes the right to access or delete the data or rectify the data. Drafting a privacy policy, cookie policy, information security policy, and making sure that people actually read it and consent to it is so important. Also, like I mentioned, creating a culture of data security. You have to constantly do it if you want to make it a culture. In terms of trainings, email reminders, how often does your IT team send email reminders to all staff? It's not just something you say once and for all. You need to constantly remind them, especially because people are busy, people can be absent-minded. So you have to constantly, send an email to say, hello, just following up. Please make sure that you only access data when you need to access such data. Make sure you don't make extra copies of documents. Make sure that you trash documents appropriately. Don't take documents out of the office. You have to make sure your IT department constantly reminds them of these things. And also, there should be a protocol for spam emails. So a lot of times I have noticed that since the COVID-19 started, there's been so much attempt by hackers, to enter law firms. You receive a lot of emails, you receive tons of emails, and these hackers are even becoming better at what they do. Sometimes you see them sending emails posing to be a partner of the firm. Sometimes you see them sending emails posing as your client. And of course, you want to get to work, you want to reply your client immediately, so you open such emails. So it's very important that you have a protocol for spam emails. A lot of people in your office, you might not know, but they might not know what to do with a spam email, whether to open it and read it or to immediately delete it. Personally, I prefer you immediately deleting an email you realize is spam. Not just deleting it in the first step, but deleting it from your deleted items, so that they do not access you in any way. So it's very important to circulate and keep your employees informed of the protocol for spam emails. You have to make sure that people don't get tempted to open it to even see what it's about, because they can really access your computer system by just you opening the document. Also, you need to audit your IT infrastructure from time to time. You need to ensure that you update your infrastructure. Like I said, it's not a one-off thing. You have to constantly update your IT infrastructure. You have to monitor user accounts as much as possible. Immediately an employee leaves the firm, you need to disable their account. A lot of people forget this, you know, when employees may have left the firm for 2 months, 3 months, and still they have access to emails and all that. No, that is wrong. Immediately an employee leaves the firm, you have to ensure that you disable their email account and all processes, their access to internal databases, so that they do not still have access to information. These are very important. Also, you have to reiterate the need to use strong passwords and change your passwords frequently. If you need the slides, I'm going to forward the slides at the end of the training. So it's going to be sent to all those who attend this training, just so that you can see the practical steps to ensure data security and also data backup. Data loss is as scary as a hack, because when you lose certain data that can never be recovered, you are literally in a dilemma, because these can be very important information. So you want to ensure that you have constantly a backup of your data. Next is resultant effects of a possible data breach. Some of you might be wondering, okay, if a breach occurs, what are the effects? What is going to happen? What's the worst thing that can happen if the breach occurs? I mean, it's not such a big deal, but I'm telling you today that it is a big deal. Firstly, you have compromised communications. So when there's a breach, there's certain confidential information that you might be sharing within your firm, and such will be compromised, because people can either intercept your communication, or people can either modify, like Mr. Shegun said, sometimes people modify information that you're sending, which is very not ideal. So you do not want to have compromised communication in your firm. Secondly, you might have the inability to access firm information due to ransomware. For example, hackers may encrypt files. You know, sometimes you might just realize that your whole, you know, files or databases are encrypted. You know, it's been hacked and you can't even access your information. And this stalls a lot of transactions sometimes. So you have to ensure that you ensure adequate data security to prevent hackers from encrypting your files and demanding, you know, and blackmailing you to restore access. Thirdly, you may encounter public leaks of personal or business information. I'm just trying to move around this fast because of time. You may encounter public leaks of personal or business information, which is something you don't want. Imagine having certain confidential client information and your client reading in the papers that certain data about them was leaked. This can be serious reputational, this can lead to serious reputational hazards. So you need to ensure that your data security is in check to prevent public leaks of personal or business information. Also, loss of client trust. This is one thing that can really affect the business, because the client no longer trusts in your ability to keep their information securely. So they don't even want to share information with you because they know that their data is most likely not going to be secure. Malpractice allegations and lawsuits, you know, they can literally, your clients can choose to bring an action against you, especially under the RPC rules, because that's going to be a breach of confidential information. And of course, like I just said, you breach your rules of professional conduct. So it's very important that you try as much as possible to adapt to these few things that I have mentioned in order to ensure that data security is complied with in your workplace. Thank you so much for listening, and please let me know if you have any questions at the end of the training. Thank you.
Okay, thank you, Moturayo. Really enjoyed your presentation. Mr. Levi? Okay, so I'll share your slides now so you can start.
Good morning, everybody. I hope you can hear me.
Yes.
Yes.
Okay. Mr. Adeyemi and Motunrayo, they have really taken the disadvantage of speaking last. So let me see what crumbs they left for me and take it off from there. So my co-speakers, they have done well to really zero into the technical industry, high-level aspect of data security. So I'll do more of zeroing in on the details of the law on data security. Motunrayo has defined data security. Mr. Adeyemi has done so as well. So I'll then look at the laws. In my slides, I listed about 6 sources where one can find data security law in Nigeria. The first is the Cyber Crimes Prohibition, Prevention, etc. Act 2015. Now, this Cyber Crimes Act, it's the major legislation or statute that governs the cyberspace in the country. So, but for our purpose, the major provision in the Cyber Crimes Act is the requirement that a data breach or an attack on a computer network is being reported by the person in charge of that network. That will be the data controller or data processor, as the case may be. Well, another thing that is interesting about the Cyber Crimes Act is that the Cyber Crimes Act also recognizes legal practitioners as a financial institution. It's a curious provision, but it goes to show the place of law firms in data security and the information systems in any country. So if you consider the fact that legal practitioners, because the definition, which I did not exactly expand here, refers to individuals or any body of persons who constitute legal practitioners. So it means it applies to a sole proprietorship kind of law firm and an associated law firm or otherwise. So this Cyber Crimes Act imposes an obligation on such data controller, in this case a law firm, to report within 7 days any incident of a cyber attack that could also affect another computer network. So if that is the case, where a law firm experiences a cyber attack and fails to report same, that means such failure is going to expose that law firm to legal liability. When I get to my discussion on the National Cybersecurity Policy and Strategy, I'm also going to mention another body which is also responsible for the governance of the cyber security, data security in Nigeria. So I move on to the Nigerian Data Protection Regulation 2019, which we commonly refer to as the NDPR. I will go over that very quickly because the co-speakers have touched on the obligations and provisions in the NDPR, but I will mention the major legal platform wherein a litigant or a client can breach. So that is the common law principle of duty of care. So every data controller has a duty of care, and this duty of care is statutorily enshrined in the NDPR. So it means that primarily, where a law firm fails to deploy all technical and organizational measures to protect data and thus result to a data breach, that law firm is primarily responsible. And a provision in the Cyber Crimes Act points out that such litigants must show that the law firm or data control all reasonable measures So it means that for a law firm to be, it has adopted all reasonable technical and organizational measures. Well, I don't know how the court will look at it when the law firm actually shows that indeed they had deployed all technical and organizational measures, and yet there was a data breach. But that's a thing for the courts to look at. Then another very major provision of the NDPR is a provision that relates to appointments of data protection officers and engagements of data protection compliance organizations. Now, the NDPR has created two new professional groups, a data protection officer and DPCOs. So these DPCOs, they assist the implementation of the data protection regulation in the country. And like Mr. Adeyemi pointed out, the governance framework for data protection and data security is very, very important. So as part of that governance framework, the NDPR created these two professional groups to be able to assist a law firm or any other data controller to ensure that data is well secured and all the tenets of data security are applied in respect of the operations of such law firm. Another important provision of the NDPR is the provision that has to do with data audits. Now, as part of the data security process, it is important that the data management system of any organization is from time to time audited to reflect that the measures, technical and organizational, are being put in place. Now, you will notice that in my talk, I continue to refer to technical and organizational measures. So let me quickly say something on that. In data security jurisprudence and data privacy jurisprudence, most of all these aspects of protecting data could be smoothly or conveniently divided into technical and organizational measures. So later on in my slide, you will see where I had pointed out the two sides of the measures, both technical and organizational. So I will now move on to the implementation framework, more like it strengthens and explains the provisions of the NDPR. So one major provision there is about the reporting of data breach. Important to know what is the timeline within which such law firm would have to report to the regulators. Now, in this case, you will see that under the Cyber Crimes Act, we have the National Cyber Security Emergency Response Team, but the implementation framework for NDPR does response team that I just mentioned. So it means that there is more like two obligations or two reporting obligations or two reporting entities that a data controller or such law firm would have to report data breach to. So in the case, another difference is in the case of the Cyber Crimes Act. The Cyber Crimes Act stipulates that such report must be made within 7 days, but the implementation framework stipulates 72 hours. So you see, there is that distinction. So it's important for a law firm to bear this in mind when it is reporting a data breach. Then again, the implementation framework outlines the required information that will accompany a notification of data breach. I didn't point them out, but there are so many things like what's the organizational framework, who are the responsible entities to manage the information system of such firm. Does the firm apply reasonable measures, what are the technical measures the firm applies, and all that and all that. Then there is the data incident breach management procedure. What's the data incident breach management procedure that the firm has in place? Motunrayo mentioned a lot about that, the protocols and all that. Then there is also the register of data breaches. So a law firm or any other data controller is required to have this register of data breaches. So that's all for the implementation framework. So I move on to the Nigerian Cloud Computing Policy 2019. Now, one I picked out like 4 aspects of the cloud computing policy that will be of relevance to data controllers and law firms generally. Now, the cloud computing policy, now this classification system enables a data controller to apportion a level of sensitivity to data security. Now, what does that mean? It means that for a data that is deemed more sensitive, it means that more effort and much stronger security systems and technical measures must necessarily be deployed for them. So we have 4 categories basically. We have the official and public data, which is not so sensitive. We have the confidential and business routine data, which is mildly sensitive, but we don't have the secret and sensitive data, which is a lot more sensitive. And we also have the classified data, which is very, very sensitive. Now, although this cloud computing policy was promulgated basically for public entities, but it is also recommended for private entities, which include law firms. So another aspect of the cloud computing policy is the CSPs. So now we now have a system of a cloud-first policy under this the Nigerian Cloud Computing Policy, which recommends the use of cloud resources as against on-premises resources. Now, the understanding is that cloud service providers, they have a much more stronger security system and somewhat more cost-effective and efficient than on-premise resources. So that is why the Nigerian Cloud Computing Policy recommends that organizations should try their best to migrate to the cloud. So a CSP here is being mandated, or rather, when you look at the contracting for cloud services, it's very possible for cloud service providers to try to limit their liability in cases of data breach. So this provision in the cloud computing policy enables a lot. The CSP is not going to exclude liability for data breaches. Now, we also have other things there, the level of cloud security, the security standards compliance, the vulnerability and penetration management that such CSP is supposed to deploy in rendering those services. Then we also have the service level agreements, which provides for the support that a data controller who uses the services of cloud service providers can actually insist that he is entitled to this level of services. So I now also move to the National Security Strategy and Policy 2021. Now, this National Cybersecurity Strategy and Policy also is relevant for cyber security and data security in the country. Now, this policy introduces, or more like defines, what is usually referred to as the critical national information infrastructure. It also introduces the critical national information infrastructure plan, the National Vulnerability Management Assessment, the National Crisis Response Plan, and very, very other lofty plans and resources that the policy introduces. Now, if you look at this policy, you will see that apart from the National Cybersecurity Emergency Response Team, we now have a National Cybersecurity Coordination Center. Now, these two bodies that are domiciled in the office of the National Security Advisor, and they are responsible for implementing the data security and cybersecurity governance in the country. So why I brought this up is that a law firm can actually draw from some of these resources. And apart from a law firm drawing from these resources, the NBA as a body regulating law practice in Nigeria can also draw from some of these plans. Given that most efforts at data security assurance could be sectoral. Now we have the financial institutions, financial services providers that CBN had promulgated the IT blueprints for financial services providers. So it means that NBA could draw inspiration from that effort, given the strategic importance of law firms. In fact, there has been moves and efforts by some think tanks and other bodies that law firms should be treated as part of the critical national information infrastructure. If you look at the National Cybersecurity Strategy and Policy, it outlines 13 sectors, including food and agriculture. Now, I was surprised if food and agricultural sector could be part of the critical national information infrastructure in the country. Why not law firms? Given the commercially sensitive and confidentiality level of the data that law firms process. We've had instances where a sitting president like Donald Trump, data in a law firm was breached. So if that's the case, it means that we could rightly say that law firms and the nature of data they process should be treated as part of the critical national information infrastructure. So if that is done, it means that the level of security that will be required and demanded of law firms will now be very heightened, and all efforts, all hands will be on deck to ensure that those standards are being met and fulfilled. So I have covered most of the data security law, and yes, we have the rules of professional conduct, which my co-speakers have already referred to, so I will move past that. So now I move to the essential data security guides for law firms and ways of securing data. Like I rightly said previously, the deployment of technical and organizational measures is very important. And then again, we have this notion that wherever data is, it must be well secured. And also, when data is to be destroyed, it must be destroyed securely. I know my time is fast spent, so I will stop here, and I thank you all for listening.
I don't think you're done with your slides yet. I think we can give you an extra 5 minutes due to the delay from the other speakers.
Okay, thank you very much, Chidinma. Why I didn't particularly go through all my slides is because most of the things in the slide has been referred to by my co-speakers. So if you look at here, the technical measures, appropriate encryption, use of firewall, data masking that could also be done via pseudonymization and anonymization of data. We have data erasure, data backup, and vulnerability and penetration test. Now, let me briefly talk about the pseudonymization and anonymization of data. Now, these are two technical tools that are used. Data is pseudonymized it's done in a way that the data cannot be reversed. You know, when you are using real data and fake data, so not reversible. But okay, in the case of anonymization is not reversible. So it means that wherever a data that has been anonymized travels to, it's not going to be possible to recover the original and real data that was anonymized. But in the case of pseudonymization, it's possible to recover them. So then for organizational measures, I pointed out things like the cyber is recommended by the implementation framework, then the disaster. Then there is this other measure that some top data security firms usually employ, or even platforms. Like we've had instances where it's called a bug bounty program. We have instances where Apple makes a call to hackers out there or people who trust their technical abilities to come forward and try to breach some of the backdoors that Apple deploys in her products. So this is one other way which a data controller or law firms can use to test their technical measures in protecting data. Then again, we have cyber insurance policies. So a cyber insurance policy, it's a new type of policy that insurance companies are beginning to offer to data controllers. And it's one way of ensuring that the business continuity is very smooth and effective. So I think I have gotten to the end of my slides. So thank you once again.
Thank you, Baba, for the presentation. The time was short for you, but really appreciate it. So there are some questions. Okay. Okay. There's a question from Ima Obong. Says, okay, she says, thank you for the presentation. Nothing from the presentation on the provision of the NDPR that persons who processes or collect data owes a duty of care to data subjects. Where a cybercrime is committed against the client of the law firm using the law firm's website, and the firm be sued for negligence by the client. Deba, did you see the question in the chat? From Imabong, she says, where a cybercrime is committed against a client of a law firm using the law firm's website, can the firm be sued for negligence by the client? You're muted. You have to unmute yourself.
Okay, yes, I refer to the duty of care that a law firm owes to its clients and for the purpose of the protection of the client's data. Now, the clients can sue the law firm.
Okay.
Now, like I pointed out in my presentation, it's very, very important for the client to show that indeed the law firm did not adopt and deploy all technical and organizational measures that would have been effective in protecting that client's data. So where that so I hope I hope that has answered your question.
Okay, thank you. There's a question for you, Mr. Shegun. Hello, sir. Mr. Shegun, can you hear me, please? Okay. I don't think it's on. Okay, so Motunrayo, are you there?
Yes, I'm here.
Okay, so maybe you would answer this question. Okay, so it says cybersecurity and data security is very important for law firm. So if there is a breach, how can the law firm manage this without it destroying the reputation of the law firm?
Okay, so I take it the question is not on the chat box, but it's just with you. Okay. All right. So basically, if there's a breach, what you do when there's a breach? Well, like we've all said, I think the best case scenario is that there is no breach, because when there is a breach, I'd like to think that things spiral out of control, like things happen very fast. Because when there is a breach of like such, depending on how large it is, but either ways, I think that it's going to be, you know, quite quite bad, because now data is in the hands of someone or a group of people that's, number one, probably have no face. You don't even know who you're dealing with. Two, it's likely data that you don't want them to have, likely data that can bring injury to your reputation, you know. So either ways, I think it's a lose-lose situation. It's either you forfeit some money financially, you know, where it's a serious case, or you have reputational issues where it blows out of proportion. So I think the best case scenario is to avoid it. But of course, where it happens in situations where you can't avoid it, I think the first thing to do is to make sure you have a system that allows you to know where there is a breach as soon as possible. So, you know, the first thing is that as part of your strategy to ensure data security, you make sure that you have a system to know immediately there has been a breach, because the faster you know about it, the better, you know, so that you can probably, you know, close off where such access is getting from, or get attention to it immediately. So the first thing is to ensure that you can know when there's a breach as soon as possible. The second thing to do is to ensure that the breach does not continue. So if you have to ensure that maybe your staff don't, because you don't know if it's from within the organization or outside the organization. So in some cases, you might ask that certain staff, maybe apart from some managerial positions, relinquish certain, you know, documents or access that they have. And basically, depending on what type of breach it is, try to solve it, you know, and then you might need to reset certain things. So for example, if there are certain passwords that you have, you might need to reset those things immediately it has been rectified, so that the breach doesn't continue. But if you have a breach in your firm, I'd like to say it means that there's a present issue. Like, it's something you need to start training your staff, because you don't know how it happened. And that's the bad thing about this breach. You don't typically know where it comes from. So you need to make sure you train your staff, you reset everything, all passwords, all access, and that you become more intentional. Yeah, so in as much as it can be injurious, it's just something that lets you know that you have work to do in relation to that.
Okay, thank you. Deva, do you have anything to add to that? Or shall I said it all?
Yes,
Sorry, your network is unstable. I can't hear you properly. So we have a final question in the Q&A. I don't know if Mr. Shegun is here with us. Okay, so Motunrayo, before we round up, there is one final question in the Q&A. It says, one member of a law firm should be appointed as a data protection officer.
I can't see that question. So could you please read it out again?
Says one member of a law firm should be appointed as a data protection officer.
Okay, good question. Basically under the NDPR, you are required, every data controller is required to appoint a data protection officer.
Okay.
So it really depends, right? Though I just want to reiterate that data protection and data security, like, they are on the same wavelength, but they're not exactly the same thing. You know, data protection officer is typically a compliance thing. So you need a data protection officer for your audit purposes and to make sure that, you know, all things are well on the data protection side of things. But data security goes beyond personal data to all forms of data. Remember, I said that. So it's just important to know that even if you have a data protection officer, you still need to ensure your IT and everything ensures data security. So back to answering the question directly, it's either you recruit somebody who is very skilled, someone who has a degree in some data, you know, maybe data privacy and protection, or someone who is very conversant, you know, with IT and stuff. It depends on the qualification that you have in your firm. Some people just look around the organization to see who is very adept with good privacy practices. It can be a lawyer in your firm. For example, in some firms, you have lawyers who typically advise on privacy and data protection, you know, like lawyers in the technology or telecommunication space. So you can just decide, oh, this lawyer advises a lot of companies and knows about data privacy and protection. So you are appointed as a data protection officer. In some other companies, especially non-law firms, where they don't really have the luxury of someone who is adept with that, they you know, employ a lawyer who is adept with data protection and privacy, or sometimes they just leave it to someone in the IT team as the data protection officer. But whatever the case is, make sure that whoever you're appointing as a data protection officer knows about data protection and privacy. Don't just give it to a random person. Make sure the person knows about the NDPR, knows in fact about the GDPR, the EU GDPR, because the GDPR also binds Nigeria so far you're providing services to residents of the EU. So whatever the situation is, make sure you appoint someone who understands what data privacy and protection is. Thank you.
Okay, thank you. David, do you have anything to add to that?
Yes, well, on my part, I want to reinforce what I said during my presentation. The requirement for appointment of a data protection officer is to ensure that at the governance level of an organization, be it a law firm or otherwise, that it is the top level staff, or it is a top level staff or a top level administrator in that organization that is responsible or that sees to that data security or data protection is guaranteed in that organization. So it means that, for instance, where we have an entity, an organization that it's a company, so if you want to really enforce or apply the understanding or the principle behind the requirement to appoint a data protection officer, it means it has to be a director. So in a law firm, it also means that senior associate that would be responsible. Now, that responsibility doesn't necessarily mean that such an officer would have all the skills, I mean the technical skills now, to ensure data security or data protection. What it just means that he is the responsible person. He is the one who oversees. He's the one who supervises. So even if he has an IT person who works responsible person. So on my part, I would say for a law firm, a partner or a senior associate, where there is one, or the most senior associate should be the data protection officer. There are, okay, in other fields where we have entities where they have chief information technology officer. So in that case, it will be easy to say, okay, the chief information technology officer is the data protection officer. So that's my understanding of the reason behind that rule.
Okay.
Thank you.
Okay. Thank you, Levi. So with this, we've come to the end of today's webinar. Thank you, Levi. Thank you, Moturai, for the profound session and the presentation you just gave today. Thank you for joining us despite your busy schedules, and we look forward to having you on our subsequent webinars. A very big thank you to our sponsors, ALEC, GLS and Co, Great Chapel, Bloomfield Law Practice, and Advocate Law Practice for making this webinar possible today. Thank you also to our attendees and to those that are bringing in questions. Really appreciate your participation. So our next webinar will be next week, Monday by 1 p.m. and the topic will be on litigation funding. Yes, so lastly, please subscribe to our YouTube channel to watch our webinars. This webinar will also be uploaded on our YouTube, and please subscribe after watching. Thank you all for attending today. It was an honor listening to our panelists. Thank you, Levi, for joining us today for your presentation. Mr. Shegun had to leave because he has an initial appointment, so he has to be ready. So thank you all and have a lovely day. Bye.
Thank you. Thank you all.
Thank you. Thank you.